A very warm welcome to everybody. I know that we have a lot of clients and friends of the firm who are participating in and watching. This is the first event in our Future of Estates campaign, which we launched earlier on this month. I want to say particular thanks to my colleagues and to Ross Murray for participating in this panel session on succession planning for rural businesses and in practice their owners around an example of an estate. Just by way of introduction, Ross Murray will probably be the best known person of the lot on this panel. Ross is an estate trustee and a strategic advisor. He's qualified as a chartered surveyor and he sits on the Rural Committee of the Duchy of Lancaster. Since 2022, he's been the Forestry Commissioner for England. He has a notable interest in the planting and management of trees. Previously, he was chairman of Knight Frank's rural practice, and he was the national president of the CLA from 2015 to 2017. And I had the great pleasure of working very closely with Ross then, and actually his rise through the ranks as vice president and deputy president. It seems only yesterday that he was president. My colleague Naomi Neville is a partner in our lifetime and estate planning team. She's a tax trusts and estates lawyer, and she works between our Southampton and Chichester offices. She assists clients with estate and tax planning, advising on wills, lifetime giving, and on the preparation of lasting powers of attorney. She also has expertise in setting up and advising on trusts and family investment companies. James Laycock, who is the third member of the panel, is a partner in our wills, trusts and estate disputes team, and also our commercial litigation and dispute resolution team. In the wills, trust and estates arena, he's built up many years of experience in cases involving challenging the validity of wills. In the commercial litigation arena, he's frequently acted in disputes concerning business-to-business contracts, shareholder disputes and claims against directors, and disputes relating to covenants. He has additional experience in relation to intellectual property claims, so a very good person when things get difficult between business owners to help you out. We have a few housekeeping notes, but I'll keep those as brief as possible. Thanks to those who've already submitted questions. There's a Q&A section in which on the screen in front of you, if you want to add questions to that, please do include your name and your email address, so that even if we don't get to the questions during the course of the webinar, then we'll be able to respond directly afterwards. We're recording the event, so it can be sent out afterwards, and if you want to view any bits of it again, or if you want somebody else to have a look at bits which you may think useful, then they'll be able to do so. And towards the end of the session, there'll be a feedback link. There aren't too many technical bits. The Q&A, as I've explained, is simple to fill in. There will be a couple of Slido questions and really online polls whilst we're doing this. Those can be accessed by the QR code, which will appear on the screen. Or the other way of doing it is simply to go to slido.com, slido.com, and type in hashtag future of estates. That's slido.com and hashtag future of estates. It's 1:05. We mailed out, I think, on Friday a couple of scenarios. We want this to be as uncontrived, and certainly we don't want it to be any more forced as a conversation than it has to be. If the actual scenarios feel in any way contrived, that's perhaps because they're contrived a little bit from a sort of multiplicity of different experiences we've had in practice, and I'm sure many of you reading them will recognise many of the warning signs. The link to the PDF is, I think, available in the Q&A. I'm just going to précis scenario 1, which is the sort of situation as we hit it for this particular family, whose family tree has appeared at the bottom of my screen, and I hope has for yours as well. We're then going to talk probably until about 1:35 for about half an hour on the first of the scenarios. And then we'll just shortly précis the second scenario and move on to really where things get into disaster territory, and one's trying to claw back things from a very difficult situation. So the situation we've posited for this is a 2,500 acre mixed estate of the sort that many of you will be familiar with. Jonathan, who has a title to pass down, and his third wife, Joanna, run it. Jonathan owns the land, but they run it in partnership, and the business sits in that way. Jonathan has two sons from the second marriage. The second wife sadly died. Thomas is the older, Harry is the younger. Thomas derives his income from the estate, Harry doesn't. There's a mixed range of interests, from land farmed in hand to tenants. There are 50 let residential cottages. There's a solar farm. There's also a literary festival. Jonathan and Joanna are reaching that interesting age of 70. They're in very rude health. And while Joanna is keen to retire, Jonathan is there. He's reluctant to relinquish control. He's hands-on. He's in the estate office 6 days a week, assisted by a resident agent who's been in place for now 25 years, and by Thomas, the older son. Both Jonathan and Joanna want to encourage their two sons to be more involved in the decision-making. And they're considering at the time the restructuring the estate to incentivize them to engage more fully. Well, Thomas studied land management at university and he's passionate about farming. He came back from a professional career aged 30, which he gave up as a chartered surveyor on the promise that he would actually have there would be a handover when Jonathan reached 65 years of age, and that hasn't yet happened yet. Harry works externally in an advertising agency. He's more involved in the literary festival, and he's keen to develop that further. Thomas lives rent-free in an estate property with his wife Tallulah and 3 young girls. Harry lives in London with his partner Hetty and baby son Hal. They have a cottage on the estate which they're pumping quite a lot of their own money into to do up so that they can rent it out as an Airbnb when they're not using it. Jonathan hasn't made a new will for more than 20 years. When he married Joanna, his third wife, he hasn't been much concerned about planning succession and things like inheritance tax, as they've been too focused on the day-to-day business decision making. But they are keen to minimise the impact of tax so they can ensure that the estate passes down successfully from generation to generation. Now, the slide has come up in front of me, and I perhaps we'll just take a moment if everyone can actually ask, is this the right time for Jonathan? Our answer is this the right time for Jonathan to begin succession planning? We've got 3 options. He should have started earlier, but now is better than never. It's exactly the right time and nothing could have been done earlier. Or this is too early, he's still wanting to remain in control and should wait. Hopefully this isn't too testing, but if people want to start giving their views on the poll, we'd be delighted to see what the consensus is out there. At the moment, 100% he should have started earlier, but now is better than never, which obviously means we've set too easy a question. But let's bowl in terms of the discussion. I mean, Ross, if you were asked either to be the next land agent in-house or to place the next land agent in-house, what would be going through your mind in terms of the scenario we've got? I mean, broadly, but also particularly with succession in mind.
James, thanks very much for the question, and thank you for asking me to join you and your clients and fellow professionals. There are 3 sort of considerations going through my mind. The first is the sort of the human one about invincibility, and very, very easy for us to all think that we're going to be just as good at 70 as we were at 50 or 40, and the risk profile is just exponential. And clearly the answer to your question is the first one. The second point I'd make is the needs of the business. In this case, an estate which I assume is a dynastic estate, and there's a general desire to keep the thing going, and who should be the appropriate family member to take that on. And Jonathan, to my mind, has overstayed his welcome, however good he is at doing it, and he has a land agent who's been there 25 years, and between them I rather suspect they're bereft of new thinking and new ideas, and clearly one or both of the boys could do that. And then thirdly, you know, there are the needs of the next generation and the frustrations around not getting stuck into a business, and also the sort of inheritance tax risk profile. So those are my sort of 3 headline thoughts if I was asked to think about a strategy for both the family and indeed for the business. And they're 2 parallel things that need thinking about.
Ross, thank you very much indeed. I mean, I think, I mean, it does go to that. I mean, particularly if you put yourself in the advisor sort of scenario of actually where you do step in, it is that sensitive but very difficult conversation actually as to how little has been done, and perhaps potentially how quickly some very key things do need to be done. But Naomi, do you have a view if you were suddenly approached, let's say, well, I mean, who are the clients here? Is there one set of clients or the three sets of clients?
Well, I think, yes, it's a tricky question. I think the clients, from my perspective, would initially really be Jonathan, ideally, because he's the one that has the power to make change at this point. That doesn't mean that the others in the family, particularly Thomas and Harry, they would certainly need to have some guidance, perhaps advice from independent advisors. Even if the family are working together with one goal in mind, it's useful to have some additional people around the table looking after the interests of those individuals as well. But taking Jonathan as the client, I think the starting point would be very much understanding the status quo and getting to grips with gathering all of the information about the arrangements, the business structures, any tenancy agreements, checking the land ownership, and understanding really what the client thinks is the current position, but also looking at what would the position be if Jonathan and perhaps Joanna too were to die in the very near future. What would the position be for tax? And if we can get an understanding of the client's goals, which are likely to be multiple across the family, and sort of taking them back to what the status quo is, that can often be quite a good driving force in helping them understand there's quite a way to go to where they want to get to, and starting with the simple and the urgent things. For example, the fact that Jonathan doesn't really have a passable will at the moment, that would really be the first task, and then you can move forward to the more complex parts of the solution.
Naomi, thank you very much. Naomi, thank you very much indeed. I mean, just before we do delve into sort of some of the things that actually would need to be addressed with succession in mind. I mean, Ross, I thinking about this in preparation, I mean, I wonder whether I would say almost there are preconditions before I'd be willing to act in these particular circumstances of things that actually really did need to be addressed. And I think Naomi touches on it, certain bits of clarity in terms of actually the business structures, the extent of what actually one is being asked to advise on and manage on, and there is a sort of, I can express it this way, there is a sort of an almost open-ended scope about this, and that's possibly one of the risks actually not doing a good job professionally.
Well, I'm sure as a legal advisor being called in, there are two things going through your mind, as they would if I was being asked to come in and advise or act as a trustee or whatever. And the first is, are you dealing with a rational family who are capable of discussing their challenges, and are they open to advice? And indeed, does there need to be a multiplicity of advisors because you've got different parts of the family there? And so, that first meeting is always going to be an interesting one, because you just don't know until you look under the bonnet of a family, and every family is different, and there's always going to be somebody who is feeling life is unfair. And the second aspect is the business. On the face of it, you don't have any experience or knowledge of this estate, but on the face of it, it looks a very valuable property, and I'm sure it is. You don't know what the debt structure is, how much burdens there are, how well managed it's been, what the condition of the various properties is, how much redundancy there is within the fabric of the estate. So if I was being called in cold, I'd be sort of thinking through all of these things. But you should go into the first meeting with an open mind, because ultimately business is, as I have often described in the past, it's social science. It's about understanding people's needs and their challenges and trying to help them. And the good professional will be very sensitive to all of these factors when they first get involved.
Ross. Ross, thanks very much indeed. I mean, I think sensitivity and open-mindedness are absolutely key. I think equally that has to be balanced with, as Naomi touched on a few moments ago, that actually there are one or two things that probably would ideally be dealt with very, very quickly in these circumstances. And just, I suppose, to amplify Naomi's point, I mean, for the time of spent initially in sorting out what may actually be a sort of a will on an almost temporary basis, putting something which actually is operable and modern and up to date and doesn't leave any room for doubt, may well act as a platform on a more secure basis for then going on to do the more detailed estate planning. But no, I mean,
a good firm of lawyers like Owen Mitchell, of course, would be able to dust off a precedent over the weekend and get it issued within 48 hours, wouldn't they, James?
The answer to that, the answer to that, I'm sure, Ross, is yes. But I think you're right about the urgency of that. I mean, I think it is moving very quickly in terms of doing something, or particularly if circumstance, actually no one could find the will in the situation we posited. But no, I mean, what else do we would you be wanting to concentrate on quickly? LPAs?
Certainly, if they haven't got any powers of attorney, yes, that would be another sort of first piece that's quite simple to start with. And working on these sort of interim will or even a full will together with powers of attorney helps you to get a really good grip on what the family goals are as well, and that helps you to then identify other issues that might need dealing with. But I think the initial review of everything would really start to flag up the other aspects that we would need to look at. Sometimes it's not unusual, it's certainly not uncommon to find clients who don't themselves have full clarity on their documentation, where everything is. They may have used multiple advisors over different years. It's great to pull all of that together. And if there is anything missing that you would expect to see in terms of evidence of the land ownership, perhaps tenancy agreements, any other business arrangements, really understanding what there is and what there isn't and rectifying that position, because in the worst case scenario, all of that's going to be needed as evidence for HMRC. But also it helps to clarify the current position for the parties involved and helps them to begin to understand where they all really stand. But in terms of substantive issues, we would look at fairly quickly. It would be good to understand if there's any scope for life insurance for Jonathan and or Joanna. Given their ages, it might be too expensive perhaps for the whole estate. But if they were minded to be making any gifts now or transferring assets down a generation now, they might want to consider some life insurance to cover the 7 years post any gifting, if there's assets being given which aren't relieved from inheritance tax. But the sorts of things they really need to be thinking about, there's a lot of understanding of the tax position first, not in my mind so that can drive the decision making, but so that they can make informed decisions about the impact of their choices. Most estate owners want to ensure that they are maximising the reliefs to make sure that they are passing down as much of the value in the estate as possible to their chosen beneficiaries. But as we know, generally, if you're sort of trying to minimise, if you're focusing in on one tax and minimising that may well have an impact on another tax. Lifetime giving, you might trigger capital gains, for example, even though you may well be minimising inheritance tax. So it's sort of really understanding the position for the family, and you can't take this in isolation. We have to be looking at all of this alongside what their general plans are for the business. If the business has a dynamic plan, any succession plan will need to be as dynamic and move and shift along with changes in the business. But there are some real basics here in the scenario that we've outlined. We need to be thinking about what does Jonathan need or want to provide for Joanna while leaving the bulk of the estate for his children. We need to look at whether there's any need for wider protective documentations, such as if they're worried about relationships of the next generation, do we need to be talking about prenuptial and postnuptial agreements, or perhaps a cohabitation agreement if Harry and Hetty, his partner, are moving in or owning, living in property owned by the estate together as they're not married, but also for grandchildren potentially too. There are really so many issues. It's very difficult to summarise in a brief moment, but I'm sure there's lots of other thoughts.
I mean, plenty of thoughts, but James, if I can come on to you, just from the point of view, you spend quite a lot of time, and very occasionally I do too, actually unpicking the sort of the business end of this when things have gone wrong. I mean, at the moment we've got a scenario which is not an uncommon one, where you suddenly find that the ownership of the land is one of the partners, or at least not the totality of the partnership. I mean, what sort of questions would you be wanting to have the answers for? I mean, imagine we've got through sort of initial engagement, but we're now starting to look at the sort of long-term planning, not so much tax planning, but actually just sort of thinking about it from a structural point of view, and actually a sort of clarity of how this is run.
Yeah, well, as everyone has alluded to already, there's a lot of moving parts here, and so our approach would be, I think, to divide it into chunks. The difficulty sometimes with scenarios like this is where there are so many different issues, you need to be careful to make sure that you're building rapport in the new relationship and not overloading it with a multiplicity of problems, and it's dividing those problems into chunks, prioritizing those that need to be done now, and then revisiting ones that can be dealt with later. In terms of the structure, the two sons are not partners. Is the partnership a right structure to take this estate forward, or is it another structure in which they are involved perhaps as shareholders? If it's a incorporated structure, then what does that shareholding look like? What does succession look like in terms of any articles, shareholders agreement going forward? How is that going to be protected? And who's going to be voting on decisions if that's the structure that you're looking at? But for those types of discussions, then one of the things, Naomi, I just wanted to sort of raise with you is because you've got so many different people involved here with different interests and probably with different aspirations, at what point would you consider speaking to Jonathan and saying, well, actually, can we get people around a table now to explore where they're coming from, what they want, to see whether or not we can structure something around those who are involved at the moment, in order to head off any potential problems in the future should a disaster scenario, which sadly we see in section 2, arise. So would you explore that early on, depending on how you're building your relationship with Jonathan?
Yes, absolutely. I think encouraging open conversation with everybody present, with the professionals involved is really helpful. However, it does need really careful management. I think particularly where you've got so many people potentially interested and involved, we would need to be very clear of what was the purpose of the meeting. And I think if this is a brand new relationship with me as advisor, I'd want to be making sure that the relationship of trust was built strongly enough with Jonathan first, so that he trusted where that was going to go, and that there's a clear sort of agenda set, and that everybody understands how that meeting's going to be managed.
What I'd like to do is go on to that piece, which is much more about the soft skills in a moment. But before we do, I mean, this is a an estate that has a solar farm. It's got, I think we said 50 cottages. We may have some opportunities, possibly for ecological mitigation for biodiversity net gain. I mean, is there anything, Naomi, that you think can be done given those, if I describe them as sort of, I mean, I'll use the word as sort of, you know, passive income streams as opposed to sort of active business streams. Is there anything to be done within the compass of any of those, do you think, to actually satisfy, or to actually get closer to satisfying the Balfour test, rather than actually sort of, you know, just adding on and sort of, you know, jumping on the bandwagon for a series of potentially remunerative in the medium term, you know, sort of land uses and income streams, but which have the risk of stuffing up the capital tax planning?
Yes, absolutely. We'd need to look at all of that. I think the sort of the piece of work we'd do at the beginning to understand the status quo would really help us to understand how that balance sits with the Balfour test for business property relief. Obviously, we'd also need to consider first the agricultural relief position. And then once you understand what the status quo is, you understand how much you can potentially shift that balance a little and still maintain the reliefs. Having said that, you know, this 50 residential lets and a solar farm, the investment income could be quite significant. Even if the sort of standard position is that the questions around time and investment of time and management time in the business might sit more on the agricultural side, and that's obviously trading activity. But I think it's one of these things that a business is, as I've said, is dynamic, and therefore we can look at these sort of give a view on the position for tax at any point, but it does need to be addressed as things change. In terms of solutions, if they are, or at least sort of things to be mindful of, the questions I'd have in my mind would be things around if Harry is more keen to develop the event side of the business, or perhaps the elements of the business that are non-farming, whether there is, as we're discussing the structure, whether there is sense in considering whether the estate should stay as one, or whether there are really two businesses here, and that will depend partly on how the land is used and where those elements are carried out. But there is scope for considering planning with the different options to try and retain as much of the inheritance tax relief as possible.
That's helpful, and moving on via the Slido slide, which I hope everyone has seen, and it looks as though everyone has voted comprehensively as to the priority for Jonathan being it's changing fairly rapidly. I think appointment of executors and trustees and whether to use trusts in the will are both ranking as important decisions for him, and I think that's right. And I mean, if we go from, and that's actually quite a neat bridge from if you like the tax planning and the harder legal reasons sort of around structuring into the sort of softer elements and discussions and the sort of, you know, the dynamics. I mean, Ross, let's just think for a moment about the roles of trustees in these circumstances. I mean, you will have seen, and I've no doubt seen, situations where the choice and identity of trustees in structures for these estates is possibly sort of make or break for the next 20 years, or, you know, maybe making no changes whatsoever, or imposing in a will trust for sort of 20 years hence, people on the next generation where you know there is potentially even real antipathy and stasis is going to and antagonism is going to set in. But I mean, what are your I suppose your prime sort of criteria when it comes to looking at who are good trustees for these sorts of entities?
Good question, James. I mean, it's a key moment, isn't it, for a family when they decide to set up a trust, and ultimately the decision of trustees should be that of the settlor, and hopefully he or she is wise about that. I think given the ages of the potential beneficiaries here, the two boys, and indeed there is the half sister as well, who we need to sort of keep a mind to, and indeed there is a wife as well. I think we're sort of reaching the stage in life where there should be sort of very sort of close consultation within the family about who might be trustees. You can often resort to third-party professional trustees who should come in with an expertise and an independence, or one could go to trusted family acquaintances who everybody knows and recognises would be wise and helpful in making decisions in everyone's interests in the future. Or you do a combination of the two, and you see how you go. But they are long-term decisions, and I think for the next generation in this situation, it's important that they have a view and trust the trustees as they come in to help manage the property. And the other critical thing is that the Set Law makes it quite clear what his or her expectations are about the future management of the property. Just going back one stage, we have of course mentioned that there is a title involved. These sometimes complicate life, and you know, I have a personal view, which is that they overcomplicate life, and there is this sort of expectation that the inheritance of property relates to a title, and I think in a way that complicates life. And I think it is a brave and far-sighted family who can slightly sort of divorce the question of a title and the inheritance of a future property-based asset, such that there is an element of quality and indeed fairness.
And I agree with that. I mean, I think the reality probably is if you are very concerned about, if you like, heredity, not just sort of primogeniture in terms of I suppose realities, but you know, but also the appearance that comes with that, and the way in which it is done, it can be dealt with some sensitivity. I mean, the scenario we've got here, actually, I think it looks as though, unless there is some sort of, you know, collateral descendant of Jonathan's sort of, you know, grandfather in the mix, that this is probably a baronetcy that's going to be fairly short-lived anyway. But you know, there are ways of dividing things up, so as not to, I suppose sort of expunge that ostensible link between the estate and the person who might be the good front man, but actually not the good manager for the property. Coming on to that conversation particularly, I mean, Ross, again, I mean, you've I'm sure had experience of trying to facilitate a family who, you know, none of whom in one way or other really want to sort of to address it. They're quite happy with their head in the sands, or worse, actually, it's a situation where there is antagonism there. And it's difficult to get people round the table when they have a lot of sort of psychological baggage, as well as potentially sort of vested interests in where they are, what they're pulling for in terms of the limits of the sort of, you know, the envelope of resources here. I mean, how would you advise going around trying to facilitate that sort of conversation?
Well, there is a cost involved, an additional cost, but there is always the potential to bring in a specialist advisor who deals with mediation within families, who sits alongside the various sort of legal and property advisors to the family. I mean, in this situation, particularly in scenario 2, which I think you're going to explain in some detail in a moment, you know, there is a need for certainly 2, possibly 3 parties to be professionally advised. And in that sort of scenario, I can see great merit in bringing in one of these new breed of professional advisors to actually do the mentoring and the soft sell of a solution. Not easy when things get contentious, that's for sure. And sometimes prospective trustees will want to just sort of step back and allow the professionals to try and find a solution before ink is put to paper.
Yeah, and I suppose that fairly small cadre of people who are, you know, I mean, in this space, delivering that sort of professional service, I suppose, with, you know, anyone who's been involved in litigation. I mean, it's not just, you know, the mediator is neutral, if you like, but it's an ongoing thing. It's about a conversation which, you know, which starts probably with each of the individuals in separate places, and it builds up to an initial meeting, and it probably continues in dialogue with all of the family members before another meeting. It's a much more spread out and a much more comprehensive process than a sort of, I think some of us who are involved in the litigation side of things are used to seeing, which might kill a dispute dead, but this is about something I think more complex. James, before we move on to scenario 2, which I'll ask you to praise it, because it falls most squarely in your sphere of expertise. I mean, did you have anything to say about trustees?
Yes, yeah, thanks, James. So trustees can be a difficult topic. Choice of trustees can be a difficult topic, but a critical one in my view, because we're seeing increasing incidents of beneficiaries asking for more information from trustees about their decision making, about the documents involved in the trust, and that presents trustees with challenges as to the amount of information they release and what they release and to whom they release it. So it comes back to choice of trustees, and in an estate like this, I suspect you'll be looking quite carefully at the candidates and their respective skill sets and marrying those to what the estate entails and what you think the challenges going forward will be. You also, I think, need, or it's a common practice nowadays, just to look at the makeup of the beneficiary class and how that will sit with the trustees in terms of personality fit. So casting your mind forward, what is it going to be like in 15, 20 years time? Is there an existing relationship now? And is this going to be a good fit between my preferred candidates as trustees, personal representatives, executors, and actually the beneficiary class that I want to provide for? Importantly, critically, your candidates have got to have the appetite to do this. And so you've got to have those discussions, obviously, at the point of appointment, but also revisit that, because hopefully there will be a long time between when you make the appointments in the will and when that comes into effect. So obviously circumstances change, and it is good practice, I think, to revisit those appointments and think, actually, are they still the right people? Do they still have the appetite? And another thing just to look at on the point of appointment of trustees or personal representatives, do they hold any positions now which could put them potentially in a position of conflict going forward? Do I need to look at whether or not my preferred candidate is also a shareholder or a director? And if so, how can I provide for that? I guess it's one for Naomi, actually. How can I provide for a conflict provision in the will? But even if I can provide for that, nevertheless, is that storing up a potential problem in the future? So just a few things there to throw into the mix when thinking about the critical appointments of executors and will trustees.
Yeah, just to add to that, having seen a professional friend of mine, sort of unbeknown to him, named as one of two executors, the one professional executor in the will, suddenly finding actually that the 90-year-old widow wasn't much help, as he had to run a 2,500 acre estate in his role as executor. That actually, yes, he was a good choice in terms of professional skill set, but actually it was in terms of the impact on his business and indeed his life, and doing the right thing, it was quite a significant impact. You do need to tell people, get their buy-in before you actually do write them in as executors and potentially will trustees. Should we move, James, on to scenario number 2? Do you want to summarise that for us?
Yes, let's do that. I'll counter through it. So matters have moved on. We're about 2 years on, and tragically, Jonathan has died in a farming accident, and thereafter, Joanna's health sadly deteriorated very quickly, and she passed away 9 months later. Before they both did pass on, there was an appetite to try and sit the family down to have this meeting that I think I alluded to earlier, and that was a fruitful discussion, which I think Jonathan wanted to then document by way of some charter or deed of family arrangement. Unfortunately, his accident came first and he never got the opportunity to do that. He died leaving a holographic will that he'd made 20 years earlier. I think probably it was a temporary measure which he had intended always to formalise properly, but just life and business got in the way, as they often do, and he never got the opportunity to do that. The holographic will provides that half of his estate is left to Joanna and half he settles into a discretionary will trust, not an uncommon instrument in wills, of which Joanna and Thomas were made trustees, and then Lottie, Thomas and Harry as beneficiaries. Joanna herself didn't make a will. She died without issue, without children of her own, and her parents predeceased her. She left a surviving brother, though, who on an intestacy takes her estate. We have also Lottie, and Lottie is the child of the first marriage. She's 32 and she lives in a cottage in the Cotswolds that was bought for her by her father, with a mortgage which he has been paying down, and also he supports her and has supported her for quite some time, over 12 years, paying about £1,000 a month to cover her outgoings. Lottie finds that with her father's death and Joanna's subsequent death, she's in straitened financial circumstances, and so reaches out to her family for assistance. Unfortunately, that is not particularly forthcoming. And finally, we have Joanna's brother, who appears somewhat robustly and starts to take charge around the estate, or trying to take charge around the estate. That creates division and problems with Thomas and Harry. And shortly, only 14 months or so after Jonathan's passing, his estate looks as though it's heading towards acrimonious litigation, but with the prospect of a mediation on the horizon, hopefully to resolve matters.
I mean, James, you deal with these sorts of circumstances day in, day out. How, I mean, you know, if we haven't got any proceedings issued yet, I think, in our circumstance, but it's fair to see tensions are mounting and heat is going into the circumstance. How, against that background, when you haven't got the pressing sort of demands of actually a live piece of litigation, do you get some people who don't want to necessarily sitting around the table? I mean, the answer may in part be, as Ross and I were discussing 5 minutes ago, you know, you need the right professional. But what's your take on that?
Yeah, so the mediation form of alternative dispute resolution might be a good medium for this type of brewing dispute. It lends itself well, but with the right choice, well to resolving things, but with the right choice of mediator. But how do you get people to the table where emotions are raw? The death of Jonathan and Joanna is recent, and people are at the moment just considering where the land lies. Well, in those circumstances, whilst you can have mediation at pretty much any point, both pre and after any proceedings are issued, clearly the earlier you can engage in something like that, then the greater the prospects are, in my view, of nipping what could be potentially very costly and very damaging litigation in the bud, and structuring some solution which caters for all the various competing potential claims against this estate. However, going to mediation too early without the necessary information, or without the appropriate information, you may not have everything, could be counterproductive. So there might have to be a period of correspondence where requests for information are made, where there is an investigative stage of trying to gather as much information about the estate and about the claims against the estate, depending on who you act for, about your client's claim, to compile all that before then proposing mediation. But as I said, in my experience, with the right mediator, this type of alternative dispute resolution does lend itself well to structuring a settlement, not least because you can do things within the context of mediation that a court may not have jurisdiction to order. So you can be creative with your solution thinking.
I think that last point is a particularly good one. There is an awful lot that you can agree which can't be imposed in a struggle which is either bilateral or trilateral and working through the court. But Ross, have you dealt personally with circumstances where you have had to to work out how to encourage these sort of parties who are heading in the wrong direction to actually to bite the bullet and pay for professional fees and to sit around the table?
Yes, I have, and sadly, this sort of car crash scenario happens, more often than one would like to think. And I would encourage everybody on this call just to think about your own personal circumstances straight after this call. Just remind you and your parents and your siblings whether they've got an up-to-date will, and also if you're a professional, to your clients as well, because without updating of one's will, acknowledging who's going to be the executor and what your wishes are, it almost always leads to trouble. I mean, the interesting thing here, to sort of add to what James has just been telling us, is that we now have 4 potential parties to a dispute or a settlement, hopefully a settlement. And you've got this brother of Joanna, for whom Christmas has arrived early and all of a sudden inherits his sister's interest. You have Lottie, for whom there must be at least a moral obligation on someone to look after and set up for the future. And then you have 2 boys, Thomas and Harry. So it's become a very complex matter, and I agree that this is clearly heading towards mediation, but how one actually gets there is the real challenge, because it's unclear to me who Owen Mitchell or whoever the law firm involved are actually acting for at this stage, and it'll need some clarity. And of course, it may be 3 or 4 firms of lawyers or different partners within the firm dealing with it. Complicated.
Just on the mediation. Sorry, James. Just on the mediation point, I always take the view that if mediation is offered, then you do need to have a compelling, persuasive argument to decline the mediation, not least because the general outlook of the courts is that if mediation has been offered, then it should be explored unless there is a very good reason for why mediation is not appropriate either at all or at that moment in time. And there are a number of case authorities where the court has made its views on certain parties refusing an offer to mediate very loud and very clear. So if you are engaging in correspondence with a view to leading up to making an offer to mediation, then you're obviously trying to gather all the information. If you then say, right, now is the time, we have all the various parties represented, we think now is the time to mediate, would your client consider mediation? There needs to be a good reason why they will decline that, or they would decline that.
And I suppose one of the ironies of the sort of circumstances we're looking at, where potentially you have got 4 sets of professionals representing different parties, is actually your ally. If you are the professional who's actually having to take the lead in trying to make this happen, is potentially, hence ironically, another party who has got a professional involved, and I suppose just think, imagine that is another solicitor, that the other solicitor may be the ally in actually trying to make this happen. Equally, it may be that actually it's the other sort of non-solicitor professionals involved who may have relationships of trust or may actually be able to help encourage others to see the benefit of the time and the effort and the financial outlay in trying to address this in a way that sees it addressed potentially before it actually becomes a live set of proceedings of some sort. But James, I mean, we've got, I think, 10 minutes or so before we come up to 2 o'clock, and at the moment I can just see a question emerging, but perhaps you just touching on, I think, particularly Thomas's claims. I mean, you know, you and I were at law school, what, sort of quite a long time ago, and it always used to be the sort of, you know, the archetype for proprietary estoppel claims were farms and estate claims, and actually then along come in the last 10-12 years a really significant number of authorities in exactly that sort of context. I mean, I think can you just give us a couple of minutes in relation to the thinking behind where Thomas is and how he might articulate his position?
Yeah, sure. So Thomas, we're told, had a promising career and was doing very well, I think, as a chartered surveyor. And he comes back aged 30 or so to the family estate, we're told, on the promise or representation that Jonathan would hand over the running of the estate when he reaches 65 years old. Now, those sorts of promises and representations are fairly frequent and fairly common, and often they're not very clear. They may be made over a number of years. They might be made over the breakfast table, and they're very, very rarely documented. You don't find the smoking gun of an email that nicely articulates a promise. That doesn't exist, or very rarely exists. And some of the representations, some of these promises are not necessarily in very clear language. They're made passing on the estate somewhere as somebody is walking by, or as I said, over the kitchen table. So the first thing is there's got to be a representation or promise that the court has to be satisfied is clear enough. There's got to be then reliance on that. So there has to be a shifting effectively of position. That might not necessarily be a financial shifting of position. It might be a question of giving up a lucrative career to take over something which isn't producing the same level of remuneration that you've historically enjoyed. It doesn't necessarily have to be that. But there needs to be some form of reliance and detriment flowing from that. So an opportunity given up, perhaps. And essentially, they're the key ingredients. We're told, of course, that Thomas has the benefit of free accommodation, in which he lives with his wife and three children. So there is a countervailing benefit, but has he been maintained by his father, and was that part of the package of the promise that he was given? Recent decision of the Supreme Court seems to suggest at the moment that where possible, the expectation arising on a promise or a representation will be given credence. So in other words, the courts will try to give credence to the expectation unless that outweighs significantly and is disproportionate to the detriment suffered. So the question, I guess, here is, Thomas has come, he's given up his career, he's come to the estate on the basis of a promise that one day it will be his. Could he get everything? Would the court give him everything? Or would the court look at the competing claims and think, well, is this an estate actually that could be divided? That goes back to Naomi's point that Thomas and Harry have different interests. So does this provide the court with the opportunity of rewarding effectively Thomas for the promise that he relied on, and making sure there is no unconscionable outcome, whilst at the same time not depriving others who have legitimate competing claims against the estate? So they are always interesting claims. They are never easy necessarily to predict the outcome, particularly where you have an estate of mixed assets like this. But again, that's why very often mediation can lend itself well to structuring something.
James, thanks very, very much indeed, and that's I think the quickest and most succinct sort of potted summary I've heard of proprietary estoppel in a long time, and it's well put. Let's come on in the last 5 minutes to some questions. Someone asked primogeniture, planning options if the client has daughters and younger siblings. I mean, the thought, to the extent we haven't already touched on that does go through my mind is actually I can think of 2 families, 2 estates in at least the last 15 years where actually, you know, something of the optics have been preserved as actually the estate has gone to a daughter whose husband's actually, you know, taken the daughter's family name. I mean, there are all sorts of things that are sort of, if I can put it like that, if one is concerned and thinking about primogeniture and thinking about maintaining a tradition that can be done, even if they're probably they were more often done in the 18th century than they are done today. Ross, what do you think about that? I mean, do you have any particular views beyond what you've already said, which is don't let titles cloud things?
I alluded to it very strongly before, didn't I? That I think male primogeniture is complicated and feels very old-fashioned nowadays, and there should be much more equality involved in these decisions. Having said that, I think that life is unfair, can be unfair, and if one regards this as a sort of family business, this estate, which needs to carry on, it probably from a tax perspective wants to be in one child's hands more than the others, and the skill will be for the advisors and indeed the settlor, if still alive, to try and sort of craft a basket of assets so that all children from whichever marriage actually are supported in some way. And I see that in families more and more. This desire to maintain a property that is viable without splitting it up in the Roman law tradition, and to try and set up other children with assets to support them. So there is an element of fairness without being totally fair.
Yeah, I'm sure we've all seen that, and that balancing exercise in itself is something that can require the tact and the wisdom of Solomon. Just one last question before we finish, and I'm not sure we're going to be able to do it justice actually in 3 minutes, but it was how to retire from a successful business and sell or transfer to existing staff rather than family who have their own successful careers. I mean, that touches on some of the points we've got a sort of division of land ownership and actually, you know, share sort of partnership business. But I mean, James, do you have any thoughts about that? Have you had to sort out things that have gone wrong when people have actually been selling businesses rather than simply trying to hand them down the generations in terms of the family?
Well, I come from it in the sort of context when things have gone wrong, and then there has to be a structure, or there doesn't have to be, but the parties work towards a structured transfer of ownership, and what you're looking at there is, first and foremost, you know, if for example the estate holds shares in multiple businesses that have operated around the estate, the landed estate, then you're looking at first and foremost actually what do the articles provide for in terms of share transition. So you're looking at the governing you've got to go back to the governing documents, what's in place, in order to determine actually what is the legal structure of any transfer here that I've got to have a look at. It's a big topic, and I think we could go back to whoever posed that question and perhaps engage separately with that. But it's a big topic, but go back to the governing documents to see first and foremost what they provide.
And I think it's the alternatives to the situation which we posited actually, and another one, and one can well see with potentially what might be heading towards us politically, by which I mean a less benign tax regime, that actually we'll see more people wanting to think about putting the heritage assets as part of an estate like this into charities. Something which seemed to have a sort of currency perhaps in the 70s and into the 80s, but one sees less of. But maybe that is that's a webinar or a podcast for another day. We're dead on 2 o'clock, and I don't want to keep anyone longer than that. I think just if we go round our panel members, just a sort of last key nugget of advice in this space. Naomi.
Yes, I think really there's been a lot of talk about fairness and things like that, and something working with any family, whether that's a landed estate like this or a smaller farm or any other business or estate. Fairness means different things to different people, and I think that it's very easy for us to assume, looking at this, that there is I mean, obviously in scenario 2 there is a dispute, but in scenario 1 there is scope there to resolve this, I think, and Jonathan has his view about what should have happened or what should happen, but actually what he thinks the children might want may not be the same as what they think they would like for themselves. And I think that open conversation and understanding how everybody feels things are fair is really important up front when advising. We can't assume anything.
Ross.
I think you've covered a range of really interesting scenarios, and the solution will inevitably rely on the chemistry between the professional advisors and the individual family members involved. I go back to my earlier advice that this is social science. Be sensitive.
James.
Touching on what Ross has just said, for me, it's communication. So often do I see problems that have arisen where there has been a lack of communication, and with no communication, people begin to imagine scenarios that don't exist perhaps, and that foments distrust and problems. So where possible, where appropriate, and when it's the right time to do so, communicate.
James, thank you. And I think for my part, it's something I introduce at this late stage. It's asking the existential question, what is the estate there for? And there may be different answers from generation to generation, but if no one actually addresses their mind to it, no one actually sort of develops any sort of vision as to why they're doing what they're doing. It just becomes an exercise in sort of in survival, and sometimes it's survival in a contest of the fittest. But I hope that's been a helpful hour for you, just as it's been a fun discussion for us. Thank you for participating. I think a link will come round with feedback, and then there'll be a recording. But watch this space. I think you've given us the idea for webinar number 2 or podcast number 3 on those alternative options. Thanks very much indeed, and have a good afternoon.